All right. So, good afternoon, everybody. Wanted to welcome you to Kenwood's Lunch and Learn program. These are events that we put on periodically exclusively for tenants within the Kenwood community. So we appreciate you participating and being a part of that. Wanted to make you aware that I'm recording today's Lunch and Learn program. We do have a pretty good number of people that will watch it that weren't available now, but we'll watch it at a future point in time. So we put it up on our website. We've done, I guess, since we started this earlier this year, we've probably done 6 or 7 now of these Lunch and Learn programs. If they are actually all reside on Kenwood Management's website. So if you'd ever like to go back and watch any of them, you're more than welcome to do that. We had most recently an economist talk about both the local and national economy. That was a good event. We've had a financial planner talk about when you own a business, what are some of the government loan availability programs that are there other than the PPP loan program that was very popular kind of in the spring for business owners. And they also talked some about succession planning for your business. Mary actually talked to our group a few months ago about HR issues specifically related to coronavirus. We also had a woman talk about marketing during uncertain times, the value of that, different ways to think about marketing and using social media, and it's just a different way to think about how you want to connect with your customers during this time, which is more in a helpful manner as opposed to just trying to sell to them. So, so again, we try to offer these once or twice a month. Exclusively to our tenant bases. This is the last one because we're coming into the holidays. So we're going to be taking the next basically 6 weeks off, and then we'll start this up again in January. So please look for our emails. You're more than welcome to attend those once we get into the new year. I don't have any idea yet on topics, but anybody has any suggestions on things that they'd like to hear, please let me know. So for today's program, Meredith Campbell, who's with Shulman Rogers, is our guest speaker. She's going to be talking about some HR issues. The program should run, 30 to 40 minutes with some questions afterwards. Probably if anybody has a question, the best way to let Mary know that is to put it in the chat box. For those of you not familiar with Zoom, if you kind of put your cursor over the screen, there'll be a ribbon that opens up at the bottom, and there's a spot there where it says chat. Just hit that, type in your question, and Mary can look at it that way. So I am going to turn the screen and the controls over to Mary so that she can run the slide. So I'm making her the host.
So much responsibility.
Lots of pressure. And Mary, there's nobody in the wait room at the moment, but just periodically take a peek at it and we should be good to go. So everybody, thank you for participating. I hope you enjoy this and you get a lot out of it.
All right. Well, good morning, everyone. I guess afternoon. Thank you so much for joining us, and thank you to Kenwood for inviting me back. I hope I'm the first repeat player for these Lunch and Learn sessions. I really enjoy the opportunity to kind of reach out to the community, and hopefully you'll find some useful information in this. As Bill said, please feel free to put comments in the chat, or otherwise let me know if you have a question. I'm even okay if you want to speak up if you want to come off mute, but most people feel most comfortable with the chat function. We have a lot of ground to cover, so I am going to run through all this material. Hopefully you can all see my screen. Somebody give me a thumbs up. All right. Thank you. Appreciate it. Audience participation. And as we go through this, if some of this is going to be generally applicable to all employers, and some are for particular industries. So lots of changes, both planned and pandemic, in the in the HR legal world. But just a minute about me and my firm. As Bill mentioned, I'm at Shulman Rogers. Well, we're a full service law firm right down the street. Holly and I were just chatting at the beginning of this about how our firm is in Park Potomac, which is right by the Founding Farmers. I'm currently broadcasting from my home, as are many of you maybe these days, but we will get back into the office soon. And so with that, I'm going to go ahead and get started. Legal stuff, because we have to do that, about our firm, just in case you have any questions. And I should mention, if anyone does at the end of this, if anyone wants a copy of this presentation, just let Bill know, and I'm happy to send you a handout from this. Let's get going. What we're going to talk about today is the FLSA, that's the Fair Labor Standards Act, the wage and hour law. We're going to talk about the executive order on race and sex stereotyping and training, diversity and inclusion. We're going to talk about Maryland laws, including ban the box, the Montgomery County minimum wage increase, and then some additional protected classes. We're going to talk about new laws in DC, including minimum wage and paid family leave, and then big changes in Virginia, the Wage Payment Act, the Values Act, bans on non-competes for low-wage employees, and low wage might not mean what you think it means, and then misclassification and whistleblower protections as well. On the federal side, we're going to talk a little bit about the NLRB, which is the National Labor Relations Board. It talks about unions. Sometimes people say, well, I can tune out at that point because I don't have a union. And I'm here to remind you that this law applies to all employers, regardless of whether or not there is a union in place. And we are seeing a lot more NLRB activity given COVID. And I can get into that a little bit more in the presentation, which is a nice segue into COVID. We will talk a little bit about COVID, both the FFCRA, which is set to expire at the end of the year, but pandemic's not over, as well as some other legal ramifications and workers' comp, reopening, those types of issues. All right, starting with the FLSA, there was an increase to the minimum salary threshold. As you remember, under the FLSA, to be exempt, there are a bunch of different exemptions. The most common, most popular are the white collar exemptions. That's a two-part test. Part one is the salary test, and part two is the duties test. That's where we talk about the administrative, executive, and professional exemptions. The salary test, it used to be $684 a week. I'm sorry, it used to be $455 a week. Now it is $684 a week, or about 35 grand, a little more than 35 grand a year, in order to even start to have the conversation as to whether or not the employee is exempt under the FLSA. There are those white collar exemptions I talked about and a bunch of other exemptions. One of the sort of forgotten about exemptions is called the highly compensated employee. That's $107,000 now, $107,432. Nice round numbers, but the highly compensated exemption is a relaxed duties test if the employee makes, what the threshold is, and it's a moving threshold. So it's $107,432 this year, but they reevaluate it on an annual basis. One thing I just wanted to point out for everyone, in case it's on your mind, we went through, obviously in March, a very difficult period in the spring where people were talking about furloughs, reductions in force. Unfortunately, I have been seeing an uptick in that among my clients. This week, I'm dealing with 2 different reorganizations, reduction in forces. So, it maybe is on the radar for some employers. Keep in mind, if you have a salaried exempt employee, someone for whom you are not paying overtime, there are limitations on furloughs. Specifically, you can't do a furlough that is less than a full work week. But there are some other creative solutions, including reduction in compensation. So if you find yourself in that situation, make sure you reach out to your legal counsel and kind of think that through, because there are some significant legal challenges, but it can be done. Next, going to talk about some additional changes to the FLSA. So when you're counting the regular rate of pay, you need to do that for your non-exempt employees, people who are entitled to overtime. You're supposed to figure out, the FLSA thinks about overtime on a weekly basis. That's why that gives us a weekly salary. So when you're doing your FLSA calculation, when you're doing your overtime calculation for your non-exempt employees, the government did recently come out with some guidance on what should be included in that number. So if you are paying parking benefits, wellness programs, specialists, there are certain things now where there was some confusion as to whether or not if you gave these perks, you had to include that when you were calculating your overtime rate of pay. You do not. Same thing with unused paid sick leave or vacation leave. Same thing with reimbursed expenses. If you are reimbursing expenses, you do not have to include that amount in your regular rate of pay. Some bonuses, coffee, snacks, these were all open questions as to whether or not employers had to include them in the regular rate of pay. They do not. So I don't know that that's really going to change anyone's daily life, other than give everybody who was worried about it some guidance. And I think to the extent people probably weren't worried about it, the most important reason why we include this is to keep in mind that calculating the regular rate of pay can be a little bit confusing. So make sure that there's lots of trips and traps, and make sure you're on top of that. Just looking at the chat, I see, and I'm reading this live, so I'm assuming that salary is base salary plus bonus and does not include other benefits. Oh, look at that. You anticipated where we were going. Nice job. Yes, there are certain things that are included and excluded, and so that's just what we were doing. And then there was another question about, is there data on what industries are reducing staff and what industries are growing and hiring? I'm not sure on a global scale. I can tell you from my own personal practice. So my practice is pretty eclectic. I work with everyone from startups to, multinational corporations. Government contractors are thriving. They're doing fantastic. Pharma companies, if they are involved in COVID, are doing great. But anyone who is outside that realm, I'm finding are having challenges. And there are a variety of challenges, and they kind of run the gamut from existential to just troubles. But we have seen across the board that employers are using this time now to look at their workforce, make sure they have the right people in the right places and the right numbers of people. So hopefully that's enough of an answer to your question. All right, so another update to the FLSA, if anyone uses the fluctuating work week rule, the fluctuating work week is a way to limit your overtime burden for your non-exempt employees. And it basically involves paying them a salary, but still tracking the time because you do have an overtime obligation. It's fairly complicated. To shorten it down a little bit, if you're doing it right, you basically get to pay half time instead of time and a half on hours over 40. So if it's not something you're currently doing, but you have a significant overtime burden and you think it might be helpful, again, that might be something you want to explore. Basically, with the update in 2020, the fluctuating work week used to be unavailable if you provided any type of bonus. So if you did any type of discretionary or non-discretionary bonus, you could not use the fluctuating work week. Now they've changed that rule so that bonuses may be given out and you can still have access to that fluctuating work week. That should give a huge sigh of relief to anyone who is using the fluctuating work week. And again, I highlight it because if you are incurring some significant overtime expenses, or if you're concerned about remote employees, perhaps being less diligent about tracking hours, fluctuating work week in some situations can be pretty helpful. Independent contractors. So this is still federal law that we're talking about here. So DOL published some guidance on independent contractors. We raise this because, of course, misclassification issues are among the most expensive for employers right now. From a liability perspective, there's two types of misclassification issues. Can anyone hear my dog barking? Sorry, apologies. Zoom work. So misclassification is the classifying someone as exempt when they really should be non-exempt, or classifying an employee as, or a worker as an employee when they really should be a contractor. So from that perspective, DOL issued some new guidance on who is an independent contractor. This is huge. I know a lot of employers are using independent contractors, and for many years, my guidance has actually been, unless you are desperate or really convinced that this is the correct classification, stay away from independent contractors, because there's a ton of liability. Just to give everyone a little bit of a nightmare, you know, there's federal liability, there's also state liability. In Maryland, if you get it wrong, the damages are up to 3 times the amount plus attorney's fees. In DC, it can be up to 4 times the amount owed plus attorney's fees, which means that not only does the liability add up very quickly, but on top of that, plaintiffs' attorneys are looking for these claims because it's easy money. Anyway, the federal government did issue some guidance, and basically the current guidance that is currently in place has 6 equally weighted factors. There is a new proposed rule which basically sort of tiers the factors, and the most important factor is economic dependence. So you know, the way I describe it to clients is, if it walks like a duck and it quacks like a duck, it's an employee, right? If the only source of income is your company, if if the worker is dependent on you for their economic survival, it's more likely or not that this is an employee. You still want to look at things like the nature and degree of control, right? That's why if you've got independent contractors, you want to make it clear that you are not controlling when the work is done, how the work is done, who does the work, right? All you're doing is saying, this is what I would like to see done, turn it into me when it's ready. And then they also look at individuals' risk and opportunity for profit and loss. And then these last factors, which are currently under the current guidance, are considered, you know, equal, and under the new guidance would be considered sort of just relevant but not really determinative. Is the permanency of the relationship between the parties. So one thing we warn clients about is that if your independent contractor has been with you for 5 years, that doesn't really walk like a duck and quack like a duck, right? You know, but now they're saying that could be okay. That's a less significant factor. They're also looking at the skill or expertise required by the individual. What they're looking for, you know, what they're saying there is, if you've got an independent contractor, it shouldn't be in your core line of business, right? So the easy example is, if you're going to hire someone to paint your walls, you're a retail business that sells things, the person you bring in to paint your walls is not going to be an employee. That's not what you do. That's a clear contractor. Your contractors really should fit more that mold than, you're selling widgets and you're hiring a contract to also sell widgets, right? If your employees are doing what your contractors are doing, you have a real risk that your contractors are misclassified. You also should keep in mind that even if this new rule goes into effect, because right now it's just a proposal, there are still other federal government rules, like the IRS has its own assessment of who is an independent contractor. Plus, there are various state obligations. So state laws, plus also state taxing authorities, have all looked at this issue. And unfortunately, it is absolutely conceivable that a worker would be considered an employee under federal law, but not under state law, or under IRS law, but not DOL law. So it is quite the minefield. And as I mentioned, the damages could be significant, and there are plaintiffs' lawyers who are looking for liability here. Moving on to the executive order on race and sex stereotype and training. A lot of people, given the cultural mood of the country, have been looking into diversity and inclusion training. The Trump administration issued an executive order. They called it Combating Race and Sex Stereotyping, but really what it's understood is to significantly limit, if not prohibit, diversity and inclusion training. This only applies to independent contractors, but there's a lot of literature out there that says, no one is quite sure of the scope of this executive order. So everyone who was really strongly looking at diversity and inclusion training has kind of put the pause on it. In terms of my advice to my clients, I've been telling my government contractor clients to hold off. Obviously, there is a new administration coming in January. The assumption is that the new administration will revoke this executive order. We certainly hope so, because diversity and inclusion training, I think, is quite beneficial to the HR environment. But right now it's on the books, and there is a hotline out there which allows employers to, employees to start reporting violations of this executive order. So again, proceed with caution. Under this executive order, just in, do we have any government contractors on the line? The primary thing, they list these criteria of what is divisive in the workforce. What it really boils down to is any training that somehow makes a particular race feel guilty, feel like they've done something wrong, or feel like they're being singled out as a bad actor is prohibited under this executive order. Again, sticking with the executive order, they talk a lot about unconscious bias or implicit bias, and that training is prohibited to the extent it teaches or implies that an individual, by virtue of his or her race, sex, national origin, is in fact racist, sexist, or oppressive or biased, whether consciously or unconsciously. My primary concern about this training is not the vendors who provide the training. I think all the vendors are doing a great job of reworking their materials to avoid violation of the executive order. But even more importantly, the vendor, that is not the purpose of diversity and inclusion training, to make people feel like they're at fault. The issue that I have is that good diversity and inclusion training leads to conversations, both part of the training or following the training. There are going to be workplace conversations, and those workplace conversations, my guess, will lead people to at least feel like this executive order has been violated. And since we can't control those conversations, that's my primary concern about this executive order, again, until we get some more clarity. Turning to Maryland employers. In the beginning of the year, Maryland passed a law that ban the box. Ban the box is sort of shorthand for criminal arrest background checks. So in Maryland, any employer with 15 or more employees is prohibited from asking questions about criminal record before the first in-person interview. So you can ask about it, but not until you've met the person in person. Lots of questions as to whether Zoom counts. I don't know. The law doesn't say. I would think that in a pandemic it would, but keep that in mind. So there are exceptions under the law if you are in an industry that requires a specific background check. So, I work with some daycare providers. Certain industries do require background checks, and there are exceptions in this law for more stringent or earlier background checks if the law allows it. Keep in mind that there are local jurisdictions with more restrictive laws, for example, Baltimore City, Montgomery County, PG County. And you also, so, just as a comparison, Montgomery County says you can't ask about criminal records until after the first interview, while as in Baltimore City, you can't ask about criminal records until after an offer of employment has been made. Keep in mind too that when you're doing background checks, you have to comply with the FCRA, not the FFCRA, because this alphabet soup is really going to drive us crazy. The FFCRA is the law that talks about COVID time off of work. FCRA talks about background checks. And there are certain obligations, hoops you need to jump through when you're doing background checks that are designed to make sure that you've got the right person, that the background check is authorized, for et cetera. Those don't go away just because you're waiting until after the first interview, or in Baltimore City until after an employment offer has been made. There's also some language from the EEOC concerns about disparate impact for employers that are using these background checks, even unintentionally, to create a pattern of discrimination. So, background checks, I think, are many employers are using them, and they're very important, but they're also fraught with concern. Montgomery County minimum wage increases, hopefully everyone's already implemented them. They were effective in July. I'm moving pretty quickly through this material because we have a lot of ground to cover, but as always, just chime in on the chat if you've got questions. Montgomery County also just passed a law with additional protected classes. This is brand new, October 6th. It's called the LGBTQ Bill of Rights. So it adds gender expression and HIV status to the list of protected classes for places of public accommodation. And then, some of these protections are already existing in the law. This just makes it explicit. And then it adds healthcare institutions, domiciliary care homes, nursing homes, and personal care homes as places of public accommodations. A public accommodation is something that's open to the public, right? So if you have office space where you're allowing people in off the street, that would be a public accommodation. If it's the easy ones are restaurants, hotels, anything that is open to the general public. Regular businesses, if you have to make an appointment to get in, that might not be a public accommodation, but for the most part, if you're open to the public, if people can come in, then it's going to be a public accommodation. DC minimum wage, if you have employees in DC, it also increased. DC has a paid family leave law. I don't know how many employers we have with people in DC on the call, but if you do, hopefully you are already aware, you've already supposed to be contributing into the DC paid family leave obligation. That happened for more than a year ago, but now employees are just now starting to be able to access that paid leave and actually use it from DC. Virginia. So Virginia had a lot of changes to their law this year. In July, they created a new private cause of action for victims of wage theft. What does that mean? Remember, I used my scary voice to talk about in Maryland, wage claims are subject to triple or treble damages plus attorney's fees. DC also has, could be quadruple damages plus attorney's fees. It used to be in Virginia, the damages were interest. And so employers in Virginia, they were not scared by wage claims. But with this new law, Virginia joined Maryland, DC, and frankly, most other states in the country to provide for damages for wage claims. It's double damages or triple if it's a knowing violation, prejudgment interest, and attorney's fees, sort of in line with Maryland and DC. There's also civil penalties, and it can be a felony, depending on how bad the act is. Virginia also passed the Virginia Values Act. 15 or more employees are now required to provide protection for increased classes, so sexual orientation, gender identity, veteran status, basically enhanced protections more in line with Maryland and DC, and not it's more significant than federal law, but not significantly more expansive. There are expanded protections relating to pregnancy, childbirth, and related medical conditions and lactation. And then there are enhanced remedies for violation of these laws. So Virginia went from being a very pro-employer state to increasing the protections and liability. Virginia also passed a new non-compete law for low-wage earners. They define low wage as $1,137 a week. There are certain restrictions and certain sort of loopholes. You can think about maybe a non-solicit. You can certainly have a non-disclosure, but you would want to avoid a non-compete, and a non-solicit can only be used in the right circumstances. There is a poster that you need to put up if you have a Virginia office. Maryland actually has a very similar law from last year, from 2019. They define low-wage earners as less than $15 an hour or $600 a week. So Virginia is significantly more than that. Next, we'll talk about independent contractor misclassification. We talked about the changes at the federal side. Virginia has also targeted this as an issue. They've actually created a private cause of action for misclassification of independent contractors. Again, if you're using independent contractors, talk to your legal counsel, make sure you're doing it the right way. The liability is pretty significant. Virginia also expanded whistleblower protection for reporting violations of the independent contractor rule. Talking about the NLRB now. Remember, that's the union. The NLRB is the board. The NLRA is the National Labor Relations Act. There was a change on offensive comments and protected activity. This is actually a pro-employer change. So it used to be that the board took a very expansive view of protected activity. So if employees raise any concern about the terms and conditions of employment, and you can imagine that in COVID times, there's lots of discussion both about safety and PPE and precautions at work, reopening at work, but also about compensation, time, leave, all of those things, work from home, remote work, all of those things are top of mind for many employees. A lot of that's going to be covered under the National Labor Relations Act, again, whether or not you have a union. But in order for it to be covered, it has to be about the terms and conditions of employment, and it has to be in a concerted fashion, meaning you can't say, I'm upset, it's got to be, we're upset. Concerted means group. In the dawn of social media, this is very difficult to figure out. If you post something on Facebook and someone chimes in, it's automatically now thought of as concerted, even though you're saying, I'm upset. If your coworkers chime in, or even if if they're your friends and can read it, there is a school of thought that has become a concerted activity subject to these protections. The pro-employer change is that it used to be that employees could get pretty heated and even use really offensive conversation. Like there were cases where employees cursed out their supervisors, but were doing it in the context of complaining about a term and condition of work. And the board said that's a protected activity and that employee cannot be punished, even though they used racist, sexist, offensive language. The new standard is that the board says if you can demonstrate that you would have disciplined this employee regardless, that you're not disciplining them because they're complaining about the terms and conditions of employment, you're disciplining them because of their language, then you can take that action. That's real important for employers to hear because consistency matters. If you have situations where people use offensive language and you do not discipline them, and then you find someone who is complaining to you perhaps on Facebook or in social media and using a racist, offensive, or just curse words, and you want to discipline them, if you haven't disciplined people in the past for similar activity, you can't do it here. And the discipline has to be similar in scope to what you've done in the past. So consistency really does matter here. Title VII, changes to Title VII. The big one is in 2020, the Supreme Court ruled that Title VII definition of sex discrimination encompasses discrimination based on sexual orientation and transgender status. Many courts and even the EEOC has already kind of taken this position, but now we have the Supreme Court weighing in and saying that's the right view. You probably do want to look at your handbook. We've talked about a lot of these laws impacting the EEO policy. When we're working on handbooks for our clients, we've updated our EEO policy to reflect some of these changes, and you might need to do the same. Coronavirus. It's on the mind, right? So let's see. I'm not going to go too far into the FFCRA. Hopefully everybody is now familiar with it. Just at a high level, remember there's sort of two buckets of leave. There's sick leave and then there's family leave. Family leave is only for, let me start. Sick leave, you can get full pay up to $511 a day for 10 days if you're sick. 2/3 pay up to $200 a day if you're caring for someone else who's sick. That's only 2 weeks. And then you can get an additional 2 weeks, or you can also use your one-time bucket of sick leave if you have a minor child at home and schools are closed. Minor is under 14. Schools are closed. Means it's not, you have the option to send them to school. The school must be closed. So that's the sick leave benefit. You only get one shot at sick leave. So if you use it to care for a minor child, you can't also use it when you get sick. You can only use it one time. In addition, you get 10 additional weeks of care for a minor child leave. So it looks like it's a total of 12 weeks for care for a minor child, but 2 of those weeks actually belong to sick leave. And so the employee has the right to choose whether they're going to use the first 2 weeks for sick leave or for child care leave. If you have questions about it, talk to your legal counsel or talk to your payroll provider. At this point, most payroll providers have been dealing with this for a while, so hopefully they can give you some good guidance. This is that poster. If you haven't already printed it out and kind of keep it handy, mine is very beat up. I look at it very often. You should have that poster up in your office, but you should also be looking, be familiar with the obligation there. It's available from DOL. Let's see, there's a question about COVID sick leave. Is this on top of what is already given to the employees? I'm not sure I understand the question, but let me just kind of walk through it a little bit. Employers might have handbook policies that provide for sick leave, or if you're in Maryland or DC, you might have to comply with the sick and safe leave laws. Montgomery County has a separate sick and safe leave law. There's that leave. That is paid by the employer. So those are statutory obligations, or if you're outside of those areas and you just have a handbook that says we give sick leave, employer pays that. FFCRA sick leave it's emergency sick leave. It's actually paid for by the government, and that is on top of any sick leave you are already providing to your employees. So if you're providing sick leave or PTO, that's you pay for it, but they get an additional bucket of sick leave for under the FFCRA. 2 weeks for sick, an additional 10 weeks for family. And the way you pay for that is actually, it's a credit against your taxes. So the next time you pay your payroll taxes, you're actually allowed to deduct what you paid out in FFCRA. So if you haven't had the joy of having to pay out FFCRA leave yet, again, I'm happy to help. Your legal counsel can help, or talk to your payroll provider. When you're using that FFCRA leave to care for a child, remember only one caretaker can take advantage of that leave. So the employee has to certify to you that they are the only adult home responsible for the children. There might be another adult home working, but they're the ones who is responsible for the minor child while the schools are closed. And you do need that in writing.
Hey, Mary.
Yeah.
Can I add one thing really quickly about the tax deduction for the FFCRA?
Yep.
That's something that is instant. You'll see it for that pay week.
You've been through it. Yeah, I mean, I thank you for chiming in. I think certainly when this first came out, a lot of employers were really worried about this, but you are getting that money. However, you might be audited, right? So keep your paperwork, make sure you've got good records that these employees are entitled to this leave, because if the government checks on your records and decides that that person actually was not entitled to FFCRA, you're going to pay for it. Good luck trying to get that money from that employee. Talking about those records, with the certification requirements, generally you need the name, the dates the leave is requested. You need a statement from the employee as to why they need the leave, and you just go back to your, FFCRA poster, just map it out. If it's based on a quarantine order or self-quarantine. So there really haven't been any quarantine orders, right? They included that in the poster because this happened, we all remember the chaos of March, right? But there really haven't been significant quarantine orders. There have been, I have dealt with clients who have had outbreaks where the CDC has said people need to stay home. We're treating that as a government order of self-quarantine. That's fine. Wherever possible, you want to get it in writing. If you can't get it in writing, just take good notes. I spoke to the CDC. They said, or I spoke to the state health department. They said these people need to stay home. if you don't have a quarantine order or communication, all you need is the name of a healthcare provider who's told you to stay home. So what often happens is there's been some exposure. You go to those employees and you say, look, there's an exposure at work. One of your coworkers, we're not going to say who, right? But an employee has identified that they tested positive for COVID. We spoke with them. They identified you're going to, as someone who had close contact, close and for a significant period of time contact. So you need to self-quarantine. Those people are typically going to be entitled to FFCRA leave. However, you're supposed to get the name of a healthcare provider. You don't need a doctor's note. Typically, they can just call the doctor and say, hey, this happened at work, I should stay home, right? And the doctor says yes, and that's all you need. But you do need to have a name of a healthcare provider unless you have something from the health department saying that these people have to stay home for the 2 weeks or until they're tested. This guidance changes all the time. I think the latest from CDC is if you are asymptomatic or you have been exposed but tested negative, you're still supposed to stay home for 10 days. If you have symptoms, I think it is 72 hours post-fever. Double check me on that. I'm not, CDC might be changing that. But you really should be looking at the CDC guidance whenever someone tests positive. If it's based on a school closing, you need some type of documentation that the school is closed. We've been getting a lot of screenshots from websites. That's fine. Again, it's not that there's hybrid school and the parents are opting out. I have younger kids in Montgomery County. We just got a letter saying, are you willing to send your kids back to school? As soon as the schools are open, if your kids are eligible to go back, you are no longer entitled to this FFCRA leave. It's only if school is not an option. In-person school is not an option. Hybrid school, what that means is some school systems are saying, you know, on week 1, this group of students is coming in, week 2, you know, those students stay home and a different group comes in, or Monday, Wednesday is one group and Tuesday, Thursday is another group. That counts as closed. So on the days that the school is not open, those parents are entitled to the FFCRA leave, which basically means intermittent leave. We can talk briefly about the Service Contract Act and its implications under COVID. Basically, if you are governed by the SCA, which means you're a government contractor, if you're governed by the SCA, you as the employer are required to continue, if you're providing health insurance for these employees, you're required to continue the benefit while the employee is out on FFCRA and the employee gets the applicable prevailing wage rate. If instead of providing health insurance as a government contractor governed by the SCA, you provide the health and welfare cash equivalent, then the rules are a little different and the employee who's using FFCRA leave is not getting the SCA prevailing wage rate. And if an employee is using FFCRA leave and SCA leave, then they do get the health and welfare benefits. It's a little in the weeds, only applies if you're a government contractor, but just want to flag it and make sure it's on your radar. Unemployment. As of right now, Maryland has suspended the 30-day search requirement, but you are still required to file a weekly claim for certifications. Virginia suspended 1 week waiting period, and DC is encouraging employees to file for benefits online. Lots happening with unemployment. I think that that's going to be a major story for 2021, but we're waiting for some more guidance from the local agencies. Workers' comp. Oh my gosh, so many calls about workers' comp and and COVID. It is still very difficult to determine where people are getting exposed. So, the lawyer in me is reminding you all that you still have to prove things, and it's very hard to prove where an exposure is. However, there is lots of guidance from various state agencies and the CDC on what to do. If you have an employee who says that they were tested positive, we've gone through this already. You ask them who at work has had close and sustained contact. We're going to get into this in a couple of minutes as to what is close and sustained. And then you want to be on the forefront of sending people home who might have had contact. That's how you're going to limit your liability. 1 case, 2 cases, I'm not worried about you being deemed liable for spreading COVID. When you have a major breakout and there's a demonstration that you don't have PPE, you're allowing people to not wear masks, you are not encouraging safe behaviors, you might have a real concern for some liability. We're going to switch and talk about the WARN Act. So under the Federal WARN Act, if you have a significant layoff, there's a notice requirement, a 60 days notice requirement. It's a little bit of a complication. If you have more than 50 employees, just reach out to your legal counsel if you're going to do a reduction in force. For federal WARN, it's 100 employees. For Maryland WARN, I think it's 50 employees. Just get some guidance and make sure you're doing it right, because it's a 60-day notice period, and it's not just wages, it's wages and benefits. So it can get pretty expensive pretty quickly. There is an exception under federal WARN for unforeseen business circumstances. So back in March, everybody was relying on that exception when they were making significant moves right away. It's no longer unforeseen. So the unforeseen business practice is no longer available. On top of that, many employers furloughed people. If you furloughed people and now you're thinking that you might have to lay them off, that could be a WARN triggering event. So again, get some guidance. In red, because I just said it, I'll repeat it. If you had a furlough that became a layoff, it might trigger WARN. And alluded to the Maryland WARN Act already. There's still some questions whether or not it is being enforced. It was supposed to go into play in October, but then they said they needed to issue regulations, and they haven't issued the regulations, and they're not anticipating them till April. So big question mark, right? That's what we like, is some certainty when we're going through these challenging times. But under the new Maryland law, if you're having a significant layoff, if you have 50 employees and you're having a significant layoff, which is 25% or 15 employees, and it's a rolling calculation, just like under federal law, it doesn't matter that it's not all happening on the same day. There's a look back and a look forward period. There is a warning, there is a notice period. And so you just want to, anytime you're doing a significant reduction in force and a significant layoff, if you can, you should consult with legal counsel. DC passed a emergency act relating to COVID. It provides, on top of sick leave, sick and safe leave, paid family leave under DC law, there's also, in addition to the federal FFCRA, there's DC FFCRA. And bonus, if you have employees in DC, the federal FFCRA is paid for by the government. The DC FFCRA leave, which is on top of it, is paid for by the employer. So lots of opportunities to screw this one up. If you have someone who is out on FFCRA leave, please take a look, not just at federal law, but state and local law if you can. Virginia passed an emergency temporary standard on COVID. And so basically it involves like reopening the office. It requires employers to take steps to control, prevent, and mitigate the spread of COVID-19. The big thing that we're seeing, most employers are already doing PPE, installing safety precautions, requiring masks, those kinds of things. But there is a requirement that you do an audit and look at classify, this is that last bullet point, classify all the job tasks according to risk level of exposure. And so that if there is an exposure at your workplace, the different job classifications are treated differently. If you have an office in Virginia, again, take a look, it's on the web, talk to your legal counsel, make sure you've got the procedures in place to avoid that liability. From the chat, are there rules and guidelines for small firms with regard to layoffs? Well, so in terms of WARN is only going to apply to the federal WARN is 100 employees. The Maryland WARN is 50 employees. Other states might have different rules. I don't know what state you're in. So if you're a small employer and if you're under those thresholds, you wouldn't be governed by the WARN Act, but you would still be governed by all the other regular employment laws. So if you're offering severance, if you're worried about discrimination, how you're selecting who's eligible for the layoff, what's your criteria, those are all opportunities for lawsuits. So in terms of rules and guidance, it's your standard employment laws. And again, talk to your employment counsel. If you're doing a significant employment move, I know it's because finances are tight and no one wants to spend any more money than they have to. But if you're doing it because you want to survive, the last thing you want to do is step into massive liability because you didn't take those precautions. Reopening, we're going to talk a little bit about best practices. First of all, you might want to think about establishing a working group. So a group of employees who are responsible for monitoring updates, changes in guidance. It changes all the time. CDC, local government, there's a lot to cover, and you want it, it's kind of like in an emergency, they always say, you call 911, right? Like identify the person who is responsible for this. Set up a working group so you've got people who are responsible for checking on this. The suggestion, kind of best practice is if you can have someone from the executive team, the legal team, and the HR team. Going back to that question about layoffs, it's same thing with COVID, the anti-discrimination laws still apply, right? So you can't say older people, you can't come to work because you might get sick. That's still discrimination. You also have to be cognizant of requests for accommodation, whether that might or might not be a disability under ADA or state and local versions of disability protection law. So these laws are still the backbone of how we do work in the United States, and you have to figure out how it's going to comply with these crazy times that we're in. If you are bringing back people from unemployment, remember that if you're offering them suitable employment and they say no, technically they're no longer entitled to unemployment. So an employee cannot voluntarily, say no thank you and still get unemployment. As employers, it is not your job to grant unemployment. We have no authority to do that, but sometimes it is helpful to remind employees, if you're saying no, if we're asked, we have to report honestly that we offered you this job. What can you ask of employees? So you are absolutely entitled to ask them if they're experiencing virus-related symptoms. I'm sure all of you have entered stores or entered places where they take your temperature. All of that is fine. You can require that employees stay home if they're symptomatic, even if they don't have FFCRA leave anymore or they don't qualify for FFCRA leave. You can tell people you cannot come in if you're symptomatic. You can require temperature testing. All these things actually are not permitted outside of a pandemic. These are, I said that we've got this bedrock of discrimination laws. Some of them have been lifted during the pandemic. So taking temperatures. You can require that employees report COVID-19 diagnoses. I know at my firm, in order to log into the computer, you have to check, electronically click the box that says that you're not experiencing symptoms. Lots of creative ways. I've got clients who have created, what are they called, QR codes. So you get tested in the lobby and then you don't get the QR code unless you signed off that you are, you've passed the screening to get into the building. All sorts of creative ways to do it, but you are permitted to do that. You can require a person who has symptoms to have a note, doctor's note, to return to work. If an employee is diagnosed with COVID-19, we've kind of mentioned this a little bit. What I didn't talk about was cleaning and disinfecting. Highly recommend, if you have a positive test for someone who's physically in your office, that you do that enhanced cleaning, again, for liability purposes. I mentioned this before. I don't think that there is a way to prove where you got COVID unless there are multiple people who are getting COVID. I don't think you're going to be considered at fault. And this is just me talking. Courts have not weighed in. But I think it's hard to demonstrate where you got COVID, but I think it's easier to demonstrate that a business did not take sufficient precautions to prevent the spread. Keep in mind HIPAA, you know, those are the privacy protections. You cannot disclose who was diagnosed as positive. People want to know because they want to know if they were in close and sustained contact. Remember, you ask the person who tested positive who they had close and sustained contact with. Close is 15 feet. I'm sorry, close is 6 feet. Sustained is 15 minutes, but now they are measuring that over a 24-hour period, which to me is bonkers and makes no sense. But sustained period could be several short interactions passing in the hall. If you've had 15 minutes over the past 24 hours, that's considered close and sustained contact. I asked the person who was diagnosed positive, who have you had close and sustained contact with? You contact those people, tell them to stay home. You do not identify who tested positive unless that person volunteers, not you ask them, they volunteered, hey, it's okay, you can tell people it was me. Then those people go home, and then you let everyone else who might have come in, who had been in that office, you let them know that there was a positive test, that you've already spoken with everyone who had close or sustained contact with that individual, that you've already spoken to them and they are staying home. Everybody else, there's no reason for you to be more concerned, you know, to take additional precautions than what you're already doing. Remember to go look at your handbook, right? Everyone probably had to experience telework. You might want to think about your telework agreement, your telework policy. Think about attendance and overtime in these remote working environments. Make sure you're recording who is present in your office for contact tracing. Some FFCRA or COVID policies, you don't necessarily want to update your handbook, but you still want to have those policies, because this will pass, right? We will return to normal at some point. So you might not want to actually implement it into your handbook, but you might want to think about changing some of your policies. Think about confidential information, people working from home, that might be different. Think about expense reimbursement. You know, people are having to buy equipment, printer paper, that kind of stuff from home, things that you might not in an otherwise reimbursed that you might have to be doing. All right, there's been lots of questions in the chat, and I've tried to address them as we've gone, but I am at the end of my planned remarks. Happy to take any questions from the group, or you can put them into the chat. All right. Oh, I've moved you all here so I could see. Sorry. Really, thank you all for your time and attention, and hopefully I covered some new information or good reminders for you.
Hey, Mary, do you want to let everyone know that they can visit your website and they will find updates and they can subscribe to your newsletter?
I would love to do that. Thank you so much. You know, as I said, if you want to reach out to at Shulman Rogers, you can find my profile. My contact information was at the start of this presentation. Happy to share all that information. I do publish alerts where we talk about changes in the law as they come up. We hold some additional webinars, that kind of informative information, but would love to get in touch. And if there's any way that we can help from a legal perspective, always looking to meet new friends and clients.
Mary, thank you so much for doing this. This was a huge amount of information. I think you presented it really well. So thank you very much on behalf of the Kenwood community. I think we all learned some stuff today. I know I did. And just want to wish everybody who's on the call a very happy Thanksgiving. It's around the corner. Hard to believe. And we hope that you are safe and healthy as we go through the holiday season. So thank you so much for participating. And Mary, thank you again for all this great information.
All right. Thank you to everyone. Bye. Thanks, Phil.
Thank you, Mary.
I'm the host. Should I end the meeting for all?